put forward as far as Section 23 is concerned on intervening. Now, BSP and TPCG already have a long-term power purchase agreement in place. Reliance, in all its, with all its due diligence, has decided not to sign a PPA even for the 500 megawatts which the Commission has permitted and TPCG has allowed it to. The Commission has been asked to intervene under Section 23 and redistribute this. So why should MERC ask Reliance to submit a legal opinion? I remember seeing this in one of the addendums to the petition document, which said that Commission has asked Reliance to submit a legal opinion. Doesn't the Commission have enough of resources and a methodology of figuring out that? Why do they need Reliance to submit a legal opinion? And in any case, having submitted the legal opinion, I don't really think they need to bother about figuring that out. If you look at the Act and the way Section 23 is positioned in the Act between Section 22 and Section 24, what 22 says is provisions where no purchase takes place, and we have Section 22, and 24 says suspension of distribution license and sale of utility. And 23 basically deals with the fact that the Commission can step in and regulate. Well, I'm not an expert as far as law is concerned, but I understand one thing. It's an established principle that interpretation of sections of an Act are to be done with respect to the position, with respect to adjacent sections, and not to be applied in isolation. So the objective behind 23 was probably to empower the Commission to step in and take appropriate steps to regulate the supply in the event the licensee's business was closing down or was to be closed down or disposed of, because that's where it's located, in between 22 and 24. It's got nothing to do with the allocation or distribution under any other circumstance. So as far as I'm concerned, I really don't think Section 23 can be used as far as the Commission is concerned for interfering in this agreement. And, oh yes, Reliance went on to state that the tariff shock, because MERC is not intervening in 23, has resulted in lots of people going into appeals at ATE, and they have specifically named Multiplex, Spencer, In-Orbit, Trent, Hypercity. I really don't see this. The facts are really twisted away. All these guys are in the retail shopping business, and the appeals probably were account of that new categorization of 89 that was done. And sure, they are facing tariff shock, but because their category has been changed by Reliance and not because of any other reason. Yeah, this is my favorite one. Yeah. Okay, we all know. And for those who don't, this is the license. It's called Bombay Suburban Electric License 1926. It was to Killick, Nixon and Company. Right? I have a copy of that. That's what it looks like. It was first assigned in 1930 to the Bombay Suburban Electric Supply Company on 13th of May. And the new company was formed just to take over the whole operation of the business because the Britishers were going out and that's what needed to be done. There was a condition imposed by the then government which said no future assignment was allowed without prior written permission. That's where the condition appears on the license. So the assignment clause says that at any time after the commencement of this license, the license may, with previous consent and writing from the government and subject to compliance with other conditions, etc., then the license can be assigned and the whole of it can be transferred. There are some other legal conditions as far as regulations are concerned. The Electricity Act in 17.3 says no licensee shall assign the license or transfer without prior approval of the Commission. Electricity business must not subsidize other business, that's in section 51, and 1/3 of the profit of other business to be deducted from AR or electricity business, that's in regulation 79.1 of the tariff regulations. Now here we had multiple changes undergoing. In December 92, the name changed from Bombay Suburban Electric Supply Limited to BSES Limited. Now, even though it's required by law, the electricity license was not amended. No application was made for transfer or assignment. In 92 to 2003, we have the Reliance Group starts investing in a very nice, good monopolistic environment called BSES Limited. In Feb 2003, new businesses were included in the Memorandum of Understanding of BSES Limited. And just for those who don't know, real estate, infrastructure, DTA, cellular, mutual funds, all of this was included in BSES Limited. In June 2003, Electricity Act came into force. In Feb 2004, BSES Limited changed its name to Reliance. Again, even though required by the law, the license is still not amended. Now here we have the Commission giving an order in July 2004, which says mere change in name in terms of provisions of the Companies Act has no legal implication and that the entity otherwise remaining the same, no fresh issue of license, etc. is required. This is the MERC's order on 1st of July 2004. But in my opinion, the law is very clear. The Electricity Act does supersede the Companies Act if there is a conflict. It also says it in section 616C of the Companies Act, and the Electricity Act has an overriding effect on the Companies Act, which is exactly stated in sections 173 and 174. So even though the Companies Act permits transfer of rights on change of name and maybe transfer of assets as well, the Electricity Act would need an application for license transfer. In this case, no transfer was ever asked for, nor ever done. And then we have, in October 2005 under RTI, we have MERC saying, with reference to your application, this is to state, no separate license has been issued to Reliance Energy Limited. This is in October 2005. Then again we have in December 2005, the government was asked. So if the license was not issued to Reliance Energy Limited, in whose name does it stand? Well, apparently it says, this is to inform you that the license was issued in the name of Bombay Suburban Electric Supply Limited. The company had not applied to Government of Maharashtra to assign the license in the name of BSES Limited. So apparently, as per these admissions, the license did not belong to BSES Limited at all. Then in 2006, the Commission again reiterated that Commission is in the process of issuing specific conditions in respect of various deemed licensees. So till 2006, the Commission has not issued licenses to anyone at all. On the license issue, there is a very interesting order at the ATE, which is there, dated 22nd of May 2006. In context of, I guess, another license issue, it says, it is seen that Reliance has not placed a copy of license in its favor, so also the contract entered into it with, I guess, TPCG has not been placed before MERC or before us. It is stated licenses and contract are lost and not traceable. Then we have Welcome March 2008. We have a new name and a new vision. Whereas this is a press release, Reliance Energy to be renamed Reliance Infrastructure, blah blah blah. However, over the past 2.5 years, the company has emerged as a leader in all areas of infrastructure business, including road, bridge, real estate and metro rail. The new name Reliance Infrastructure will adequately reflect the current nature of businesses and is in line with company's vision to play a vital role in emerging infrastructure. I think this means that the company has changed its business focus, unless I do not understand simple English. Then we have another RTI reply in June of 2008, very recent. Commission has not authorized Reliance Infrastructure Limited for distribution of electricity. What are we supposed to make of this? Do they have a license? Do they not have a license? Are they authorized? Are they not authorized? Yet, in July 2008, Reliance Infrastructure releases an ad on the question of renewable energy and says, Reliance Infrastructure Limited is an electricity distribution company with distribution license to supply electricity, etc., etc., etc. And now we have in August 2008, MERC finally trying to reconcile the mess by issuing specific conditions of distribution license, where, and it very strangely says, applicable to Reliance Energy Limited. Okay. Further on, if you read closely, it says in exercise of the powers under 181(2)(d with proviso to section 16. Okay. What does the proviso to section 16 say? Provided that the appropriate commission shall, within 1 year from the appointed date, which would be June 2003, the Electricity Act came into force. So 1 year from the appointed date would be June 2004. Okay. Specify any general or specific conditions of license, etc., etc. This proviso to section 16 should have been used within 1 year of the Electricity Act coming into force, not within 4 years of the Electricity Act coming into force. It further goes on to say, REL or distribution licensing means Reliance Energy Limited, in brackets, now known as Reliance Infrastructure Limited, etc., etc., etc. But Reliance Energy Limited has ceased to exist. There is no entity as on this date. Because on 24th of April 2008, the name got changed. The company is no longer in existence. If MERC wanted to draw a reference to REL's original application for transfer, which I assume, it would have issued regulations in favor of Reliance Infrastructure Limited, in brackets, formerly known as Reliance Energy Limited, which is the correct legal manner of representing such issues. In another order in November 2008, MERC goes on to ever that Commission clarifies that the Commission had recognized the change of name of the company. Is recognition of name change equal to assignment or transfer or issue of license? Doesn't the license itself have to be endorsed, stamped or amended? Oh, I forgot. The license is lost, right? So what are you going to stamp?